Senator Tulujan.
Honourable Senators, before I begin, I would just say that a free and independent press is one of the cornerstones of democracy, and as such, I was elated to learn of the release of the Reuters reporters held in Myanmar after more than 500 days in prison. I rise today in support of Motion 476. I have been speaking about the situation of the Rohingya in Myanmar in the Senate for the past many years. In September of 2017, I spoke in this chamber specifically about the brutal and horrifying situation that the Rohingya people in Myanmar were enduring at that time. I spoke of widespread systematic attacks and gross violations of human rights against Rohingya people being perpetrated by the Myanmar government forces, including sexual violence, rape, mass gang rape, torture, extrajudicial and summary killings of civilians, including infants and children, arbitrary detention and enforced disappearances, systematic evictions, families burnt alive in their homes, torching of villages, and indiscriminate attack against those fleeing, including the shooting of women and children. The attacks were in breach of international human rights conventions, international law, and international criminal and humanitarian law. Furthermore, the Myanmar government failed to uphold its responsibility to protect the civilian Rohingya minority population and must face justice. At the time, the attacks were mostly referred to as crimes against humanity and ethnic cleansing, notwithstanding that the international experts warned that the situation in Myanmar had every hallmark of the genocides in Rwanda and Bosnia. 1 year later, the Parliament of Canada formally recognized the attacks against the Rohingya people as genocide. Subsequently, the United Nations Independent International Fact-Finding Mission on Myanmar found sufficient information to warrant the investigation and prosecution of senior Myanmar military officials on charges of genocide. It found that genocidal intent, meaning the intent to destroy the Rohingya in whole or in part, could be reasonably inferred. In its interim report on the situation of the Rohingya, the Standing Senate Committee on Human Rights recommended that the Government of Canada continue engaging with UN member states to ensure that the perpetrators of crimes against the Rohingya were held accountable. As we have learned from Rwanda and the former Yugoslavia ad hoc war crimes tribunals, accountability is a vital component in the healing process of victims, witnesses, and their families. Honourable Senators, it is generally understood that the court best situated to prosecute those who perpetrate such crimes as genocide is the International Criminal Court. However, as Myanmar is not a state party to the ICC, it is barred from exercising its jurisdiction over crimes committed within Myanmar. In fact, the ICC has already ruled that since Myanmar is not a signatory to the Rome Statute and Bangladesh is, the court may only exercise jurisdiction over the alleged deportation of the Rohingya people from Myanmar to Bangladesh. The only way the ICC could exercise its jurisdiction over the crimes committed in Myanmar would be if the UN Security Council referred the matter to the court. However, a referral would require the support of China, who enjoys a close relationship with Myanmar, including strong commercial relations, and moreover holds the power of veto in the Security Council and would therefore almost certainly block any such attempt. In the light of this, and in order to seek provisional measures and repatriations for the Rohingya people, the motion before us asks that the Government of Canada to invoke the Genocide Convention and pursue the matter before the International Court of Justice, a court which decides legal disputes submitted by states. To this point, Professor of International Law at McGill University, Payam Akavan, and Professor of Law and Director of the Human Rights Research and Education Center at the University of Ottawa, John Packer, published an analysis recently in the Center for International Policy Studies blog affirming the International Court of Justice has jurisdiction over the crime of genocide and that Canada could immediately bring a case against Myanmar based on the available evidence, that Canada and Myanmar are both signatories to the 1948 Genocide Convention, and that Article 9 of the treaty confers jurisdiction on the ISJ to determine the responsibility of governments, including their failure to prevent or punish perpetrators of genocide. In this regard, the Government of Canada must uphold its positive duty under the Genocide Convention, and demonstrate global leadership in the promotion of international human rights by engaging with like-minded states to pursue the matter before the ICJ. Furthermore, unobstructed access to Rakhine State by independent monitors in order to investigate the international crimes committed is of paramount concern. As such, the Organization of the Islamic Conference underscored in a recent resolution the need to establish the facts of the situation on the ground in Rakhine State through an independent investigation body, and in this regard noted with concern that the government of Myanmar has ceased cooperation with the UN mechanism. Canada can and must do more with its global partners to facilitate unfettered access to Myanmar, in particular Rakhine State. The protection of estimated 530,000 Rohingya who remain in Myanmar is also of paramount concern. Ensuring that humanitarian organizations have access to affected communities is an urgent priority, as is the ability to monitor the security and human rights situation on the ground, again particularly in the Rakhine State. Furthermore, in its study, the Senate Committee on Human Rights heard repeatedly that the need for humanitarian aid to the more than 1.1 million Rohingya refugees who have fled in Myanmar is monumental and dire. The majority of the refugees are concentrated in Cox's Bazar, where a lack of food, water, as we heard Senator Omidwar mention, shelter and sanitation is prevalent, as is sexual violence and human trafficking, limited access to healthcare and trauma services. These issues were addressed in the Human Rights Committee's recommendations to the Government of Canada, also calling for particular attention to the needs of women, girls, and the provision of education. Honourable Senators, I cannot stress strongly enough the level of humanitarian crisis facing Rohingya refugees and also the Government of Bangladesh. The Government of Canada must continue its provision of assistance to the Government of Bangladesh through multilateral aid, which seeks to address both the short and long-term humanitarian needs of the Rohingya refugees. I would like to thank Senator McFadden for moving this important motion, which I support and ask that you do as well. To quote Professor Akawan and Packer, there will always be political reasons not to do anything, to remain as bystanders, rather than taking a risk to achieve justice. But what do we as Canadians want to remember when we commemorate the 25th anniversary of the Rohingya genocide? Can we enter the ranks of the Good Samaritans like Raoul Wallenberg, who helped rescue Jews during the Holocaust? Or General Romeo Dallaire, who rescued Tutsis in Rwanda in 1994? Surely Canada can and should be on the right side of history. Thank you.